May 14th, a governor of Virginia received a formal written warning directly from the United States Department of Justice, stating that if she signed certain gun bills into law, the federal government would sue her state. She signed them anyway, and within 24 hours, everything exploded. I need you to understand something before we go any further. I have followed Second Amendment law for years. I have watched states pass unconstitutional restrictions. I have watched gun owners fight back through the courts for half a decade, and I have watched the federal government sit on its hands through all of it. What is happening right now today, May 28th, is different from anything I have seen before. And I do not say that lightly, because this is not just about Virginia. The legal battle that ignited 2 weeks ago is going to determine what gun rights look like in New Jersey, New York, California, Illinois, and every other state that has been pushing the boundaries of the Second Amendment for years. There is a clock running, July 1st, 34 days from now. That is when this law takes effect, unless a federal court stops it first. If you are serious about understanding what is actually at stake here, subscribe right now, because this story is moving fast and you cannot afford to be the last one to know. To understand why what just happened in Virginia is genuinely unprecedented, you need to understand the game that has been played for decades, because once you see it clearly, you will never look at state gun laws the same way again. Here is how it has always worked. A state legislature passes a gun restriction. Does not matter if it directly contradicts Supreme Court precedent. Does not matter if it bans firearms owned by tens of millions of law-abiding Americans. Does not matter if there is zero historical basis for it under the Constitution. The moment that law is signed, it takes effect. And the burden, every dollar, every year, every ounce of energy falls entirely on gun owners to fight back. They have to find plaintiffs, find attorneys, file in district court, lose the preliminary injunction motion more often than not, appeal to the circuit court, wait, appeal again, potentially wait years for the Supreme Court to even consider the case. And during all of that time, 5 years, 6 years, sometimes longer, the law is being enforced. Gun dealers are turning customers away. Law-abiding citizens are being told the firearm they legally purchased is now subject to new criminal penalties. People are being prosecuted under laws that will eventually be struck down. The state bears essentially zero immediate consequence. The gun owner bears everything. That has been the game, and states have been playing it expertly for a very long time. Now, before we get into what changed, you need to understand the constitutional foundation that makes this moment possible. Because without it, none of what the Department of Justice just did would carry any legal weight. In 2008, the Supreme Court decided District of Columbia versus Heller. That decision established for the first time that the Second Amendment protects an individual right to keep and bear arms for self-defense, not a collective right, an individual right, foundational. In 2010, McDonald versus City of Chicago extended that protection to the states, every state, no exceptions. Then came the one that changed everything. In 2022, New York State Rifle and Pistol Association versus Bruin. The court established a new test, one that shifted the burden completely. Under Bruin, the government must now justify any gun restriction by pointing to a historical tradition of similar regulation from the founding era of this country, not modern policy arguments, not crime statistics, historical tradition. And if that tradition does not exist, the restriction cannot stand. Most assault weapons bans fail that test, flatly, completely. The historical record simply does not support them. That is the legal foundation. Keep it in mind, because everything that follows depends on it. Now let me introduce you to the person at the center of this story, because most coverage you have seen treats this as a nameless, faceless government action. It is not. There is a specific individual who built this, who signed her name to it, and who is now personally driving what may become the most significant Second Amendment enforcement campaign in American history. Her name is Harmeet Dhillon, Assistant Attorney General for Civil Rights at the United States Department of Justice. In December of 2025, Dhillon did something that had never been done before inside the Department of Justice. She created a dedicated Second Amendment section within the Civil Rights Division. A team of attorneys with one specific mandate: identify unconstitutional gun restrictions across the country and dismantle them through federal litigation, not reactive litigation. proactive enforcement, the same machinery the federal government has historically used to protect voting rights and housing rights, now pointed directly at Second Amendment violations. And here is something the headlines almost never mention. Approximately 70% of the attorneys who previously worked in the Civil Rights Division left after Dhillon took over. The priorities shifted completely. New lawyers came in, new mission, new targets. Whether you agree with that shift or not, and reasonable people disagree strongly on this, the operational reality is that Dhillon now commands a division rebuilt from the ground up around a single constitutional objective. On April 10th of this year, she sent a formal letter to Governor Abigail Spanberger of Virginia. Do not picture a polite note expressing concern. This was a legal declaration. The letter stated plainly, and I am going to be precise here because the specific language matters, that the Civil Rights Division would, quote, commence litigation in the event the Commonwealth of Virginia enacts certain bills that unconstitutionally limit law-abiding Americans' individual right to bear arms. That is not a suggestion. That is a promise of federal action, put in writing, delivered to the governor's office. Now pay attention to what Dhillon cited inside that letter, because this is the part that most people completely missed. She referenced Executive Order 14206, signed by President Trump in February of 2025. That executive order directed the entire federal government to actively protect Second Amendment rights, not simply avoid undermining them, but actively protect them. That order is the legal and administrative foundation for everything Dhillon's division is now doing. She also cited a Supreme Court decision from 2025 Smith & Wesson Brands versus Estados Unidos Mexicanos, in which the court described AR-15-style rifles as, quote, widely legal and bought by many ordinary consumers. A sitting Supreme Court in 2025 putting those words into the official record. And she cited Justice Kavanaugh's statement referencing arms possessed by literally tens of millions of Americans. Do you see what she built? She did not write an opinion. She assembled a legal argument from Supreme Court language, executive authority, and constitutional precedent, and delivered it as a warning shot directly to a sitting governor. The letter concluded with words that left no ambiguity whatsoever. The Second Amendment rights of law-abiding citizens shall not be infringed. I want you to stop for a moment and sit with what just happened. A senior official of the United States Department of Justice formally placed the right to own commonly used firearms in the same constitutional category as the right to vote, the right to fair housing, the right to equal protection under the law. Rights that the federal government does not wait to defend. Rights the federal government actively enforces before the violation takes hold. That framing that specific elevation of the Second Amendment into civil rights enforcement territory is the thing that changes everything going forward. Not just for Virginia, for every state watching what happens next. Here is where the story takes the turn that nobody fully anticipated. Spanberger had a choice. She knew the Department of Justice was watching. She had the letter in her hands. She had seen the language commence litigation, seek injunctions, stop enforcement before these laws take effect. She understood what was coming, and then she tried to thread the needle. Before the final vote, Spanberger proposed an amendment to Senate Bill 749. She wanted to carve out an exemption specifically for firearms, frequently used for hunting, a political compromise, a way to sign something without signing everything. Her own Democratic colleagues in the General Assembly looked at that amendment on April 22nd and said no. They sent the original bill back to her untouched. No exemption, no modification, take it or leave it. So now the choice was completely binary. Sign the bill as written, veto it entirely. Or do nothing and let it die unsigned. She signed it, May 14th. Late in the evening, with what her office described as a statement about public safety. Her exact words, and I want you to hear this carefully, were that firearms designed to inflict maximum casualties do not belong on our streets. Now, set aside for a moment what you personally believe about that statement. Look at it purely from a strategic and legal standpoint. A governor just received a formal written warning from the federal government's Civil Rights Division. She had every political justification to veto. She could have cited the pending litigation risk, the constitutional uncertainty, the federal conflict. Instead, she signed. And in doing so, she made a deliberate decision to let the courts decide. Why? That is the question worth sitting with. Is this about genuine conviction on public safety? Is this about building a national political profile ahead of a future campaign? Is this about responding to pressure from an urban voter base that delivered her the governorship? I am not going to tell you which of those answers is correct, but I am telling you those questions are worth asking because the answer shapes how you interpret everything that follows. Now here is what followed, and this part happened fast. Within hours of the signature, the National Rifle Association, joined by the Firearms Policy Coalition and the Second Amendment Foundation, filed suit in federal court. That same night, asserting that Senate Bill 749 violates the Second Amendment by criminalizing the purchase and sale of commonly owned firearms. The next day, May 15th, the National Shooting Sports Foundation funded a separate lawsuit, Black v. Hook, filed in the Circuit Court of Fauquier County, Virginia, state court. And this one went further. The plaintiffs in Black v. Hook did not just argue federal constitutional violations. They argued that Senate Bill 749 violates Article 1, Section 13 of the Virginia Constitution, which independently protects the right to keep and bear arms under state law. Two simultaneous legal campaigns, federal court and state court, both launched within 24 hours of the governor's signature. And then came the detail that I think tells you more about the real situation on the ground than any courtroom filing ever could. Sheriffs, local law enforcement. In Amherst County and Campbell County, Virginia sheriffs publicly stated that they believe this law goes too far and conflicts with the Second Amendment. These are the people who would be responsible for enforcing Senate Bill 749 starting July 1st, and they are already signaling resistance. Think about what that means practically. You have a law that the federal government says it will challenge. You have lawsuits filed in both federal and state court. And you have local law enforcement in multiple Virginia counties publicly questioning whether they will enforce it at all. 34 days. July 1st is 34 days away. And right now, nobody, not the governor, not the Department of Justice, not the NRA, not the sheriffs, nobody knows exactly what July 1st looks like. Subscribe right now if you are not already, because the moment a federal judge rules on the injunction request, and that ruling could come any day, I will break it down for you immediately. This is not the kind of development you want to read about secondhand. Here is what most coverage of the Virginia story is completely missing. Virginia is not the only battlefield. It is not even the most advanced one. While every camera was pointed at Richmond, the Department of Justice was simultaneously opening legal fronts in multiple cities and jurisdictions across the country. And when you step back and look at all of them together, what you are looking at is not a reaction to one state's legislation. What you are looking at is a coordinated, deliberate, nationwide campaign to dismantle state and local gun restrictions through federal civil rights enforcement. Let me walk you through what is happening right now in parallel while the Virginia injunction battle is playing out. Denver, Colorado. May 5th, 9 days before Spanberger signed Virginia's bill, the Department of Justice filed suit against the city of Denver over an assault weapons ordinance that has been on the books since 1989. 37 years. This law predates the internet. It predates the modern smartphone. And the Trump Department of Justice just walked into federal court and said it is unconstitutional and must be struck down. Acting Attorney General Todd Blanche put it in language that was impossible to misread. The Constitution is not a suggestion, and the Second Amendment is not a second-class right. Denver's ordinance, like Virginia's new law, bans semi-automatic rifles and restricts magazines over 15 rounds. The parallel is not coincidental. Washington, D.C., May 14th. The same day Spanberger signed Senate Bill 749 in Virginia. The Department of Justice filed an amended complaint in federal court against the District of Columbia over its categorical ban on AR-15-style rifles and suppressors. Same day, two jurisdictions, two simultaneous legal actions. And Dhillon's argument in both cases rests on the same foundation. These are the most commonly owned rifles in America. They are constitutionally protected under the Heller framework, and no government authority has the power to ban them categorically. But it goes further than Denver and Washington. Los Angeles, California. Dhillon's investigation revealed that the Los Angeles Sheriff's Department had approved just 2 concealed carry applications out of more than 8,000 submitted. Interview wait times stretched up to 2 years after a completed application was received. 2 approvals out of 8,000. The Department of Justice is now formally targeting that system as a civil rights violation. Massachusetts. The state maintains what is called an approved firearms roster, a list that effectively bans the commercial sale of many common handguns, including popular models that law enforcement agencies across the country carry every single day. Dhillon has identified this as flatly unconstitutional. United States Virgin Islands required home inspections and a proper cause showing just to own a firearm nearly identical to the system the Supreme Court already struck down in Bruin. The Department of Justice has already sued. Now step back. Look at all of that together. Denver, Washington, Los Angeles, Massachusetts, the Virgin Islands, Virginia. These are not isolated cases being handled by different teams with different priorities. These are coordinated actions flowing from a single strategic decision to treat Second Amendment violations as civil rights enforcement priorities requiring proactive federal intervention. Dhillon has been building this infrastructure since December of 2025, hiring attorneys specifically trained in Second Amendment litigation, constructing what she has described as a cadre of lawyers prepared to challenge unconstitutional gun restrictions all over the country. Now here is where I need to give you the full picture because intellectual honesty demands it. This campaign is not without serious opposition. Janet Carter, a Second Amendment litigator with Everytown Law, argues that the Second Amendment has never been an absolute right and has always permitted regulation of particularly dangerous weapons. Colorado's Attorney General Phil Weiser has vowed to vigorously defend his state's magazine capacity law against the federal challenge. And critically, the Fourth Circuit Court of Appeals, which covers Virginia, has existing precedent upholding Maryland's assault weapons ban in a case called Bianchi versus Brown. Dhillon's own letter to Spanberger acknowledged that precedent exists and called it wrongly decided, but a federal district court in Virginia is bound to take that circuit precedent seriously. The outcome of the injunction request is genuinely uncertain. Anyone telling you otherwise is not being straight with you. Now I want to slow down, because this is the part where most commentary either oversimplifies or picks a side and stops thinking. I am not going to do that. There are 3 questions sitting at the center of this story that almost nobody is asking clearly, and the answers matter regardless of where you stand politically. Question 1. Will the court actually grant the injunction before July 1st? To block Senate Bill 749 before it takes effect, the plaintiffs need a federal judge to grant a preliminary injunction. That requires meeting 4 specific legal criteria: likelihood of success on the merits, irreparable harm to the plaintiffs, balance of equities favoring the injunction, and consistency with the public interest. Under the Bruin framework, the merits argument for the plaintiffs is genuinely strong. AR-15-style rifles are demonstrably in common use. The government cannot point to a founding-era historical analog for banning them. On paper, likelihood of success looks favorable. But here is the complication that changes the calculation significantly. The federal district court handling this case sits inside the Fourth Circuit, and the Fourth Circuit currently has standing precedent Bianchi versus Brown upholding Maryland's assault weapons ban. A district court judge is not required to follow that precedent mechanically, but it creates real friction. It gives a cautious judge a reason to hesitate. The injunction is not guaranteed. And if it is denied, Senate Bill 749 goes into effect July 1st while the full case works its way through appeals that could take years. Question 2. Is what Dhillon is doing legally consistent, or is this selective constitutional enforcement? This is the question that the opposition is raising, and it deserves a straight answer. Critics, including Democratic senators who have formally written to Dhillon, point out that approximately 368 attorneys left the Civil Rights Division after she took over. The division that was built to enforce voting rights, combat police misconduct, and protect marginalized communities has been fundamentally restructured. Whether that restructuring represents a legitimate reordering of constitutional priorities or a political weaponization of federal legal machinery is a question reasonable people are actively debating. I am raising it here because you deserve to have it raised. Draw your own conclusion. Question 3. What does this mean for you, regardless of what state you live in? If the federal court grants the injunction and blocks Virginia's law before July 1st, the signal to every other state legislature considering similar legislation becomes immediate and concrete. Federal intervention is real, it is fast, and it carries consequences. Some legislators who might have voted yes as a political gesture will recalculate. If the court denies the injunction, the Fourth Circuit's contrary precedent gets reinforced. Every future challenge in Virginia, Maryland, West Virginia, and North Carolina becomes harder. The constitutional momentum built by Bruen faces its most significant obstacle yet. This is what lawyers call a bifurcation point. A moment after which the two possible paths diverge so sharply that returning to the starting point becomes essentially impossible. We are standing at that point right now, and the judge has not ruled yet. Let me bring this home with 3 things I need you to walk away understanding clearly. First, for the first time in American history, the federal government's Civil Rights Division is actively enforcing Second Amendment rights, not waiting for gun owners to spend years fighting alone, but stepping in proactively with federal authority and federal resources before violations take hold. Second, Governor Spanberger received that warning, looked at it directly, and signed Senate Bill 749 anyway. Within 24 hours, lawsuits hit from every direction: federal court, state court, the NRA, the Second Amendment Foundation, the Firearms Policy Coalition. Local sheriffs are publicly questioning enforcement. And a clock is running 34 days. Third, this is not a Virginia story. Denver, Washington, Los Angeles, Massachusetts, the Virgin Islands. The Department of Justice is fighting on every front simultaneously. What happens in Virginia's courtroom will send a signal to every one of those battlegrounds and to every state legislature currently drafting the next round of restrictions. Now, here is the question I want you to sit with. If the injunction is granted and this law is blocked, what does your state's governor learn from that? And if it is denied, who actually pays the price? Drop your state in the comments below. Tell me which gun law concerns you most right now. I read every single one, and your answer is going to shape the next video directly. Subscribe and turn on notifications, because the moment a federal judge rules on this injunction, and it could happen any day now, I will be here breaking it down before anyone else does. Do not be the last one to know.